Hi, I'm Michael H. Cohen, founding attorney at Cohen Healthcare Law Group. In today's video, we'll talk about what you need to put in the name of a California Professional Medical Corporation, affectionately known as a PMC. And the rules in California are very, very specific. So number one, you need this professional designation that it's a professional corporation. Words like professional corporation or PC, that's not politically correct, it's professional corporation, or Prof Corp. So for example, our law firm, Cohen Healthcare Law Group, PC, used to be APC, a professional corporation. Secondly, there's certain permitted words, and the words really should indicate the specific profession or type of services. For example, dermatological practice, or IV hydration clinic, or medical spa. Third, the name has to be distinct from other names of similar entities in California so that the consumer is not confused. And then last, typically, but not always, typically, I'm going to give you an important exception. You want to include the physician's name. For one, it's a common practice. And secondly, it helps with the branding and the recognition, especially if it's a well-known doc. And there might be other, like very specific medical board or Department of Public Health regulations, depending on the exact type of practice or company or clinic. So, you will want to check with us, but these are the general rules. Another point is that if you've got a corporation that, say, has a 51% MD owner and a 49% nurse, you might want to put the physician's name in the title so that nobody gets confused about the ownership of the corporation. Now, a lot of these rules are common sense, and you have to be careful because even if you do follow these rules, there can be what I call a collateral line of attack. So, for example, you could have the medical board or some other agency come in for another reason. They might just say that the name is not good enough, it's false and misleading, it's deceptive advertising. So you're going to want a healthcare lawyer's eyes on this simple, even though precisely defined, persnickety little point of California law, which is how you name a professional medical corporation. Now, one exception. Let's say you're not the physician, but you're the MSO. You're the driving business that's going to brand this medical spa across states. Then you have to kind of work with these rules to make sure you accommodate them. But you also want to brand the MSO. So you could come into creative arrangements, like, for example, licensing a name. So how do you deal with that? We have some more resources on our blog, and also we'd love to work with you. We help hundreds and hundreds of clients every year. So if you're interested, please give us a call, and we'd love to get you started.